Supplementary list, item number 1. I am the pro forma 1 and 2.
Well, there were 2 writ petitioners before the learned single judge. Well, the first writ petitioner was arrested on 7th of September and will produced before a magistrate on the 8th.
1 minute. Who is appearing for the 8th?
We have served the writ petitioners.
Sir, may I hand over the service? I will have service.
Who is appearing?
Please.
Your Lordship, we have served. Your
Well,
Lordship.
before the learned single judge, Mr. Shubhish Shanal had appeared with
The advocate on record was Voxy. We have served on the advocate on record on his email ID.
Now, here what happened was, 2 persons, they were arrested in connection with a case. Initially, one of them was sent to JC. Then, both of them were sent to PC for 3 days. That is from 9th of September to 12th of September. Then again, they were sent to JC. And finally, they were enlarged on bail, on 5th of October 2024. But in the meantime, on 17th of September, the instant writ petition was filed, affirmed through Todbirka. Now, if your Lordship may kindly have a look at one paragraph of the writ petition, which is paragraph 7, my Lord will find it. My Lords will find it at page 32. What is the case before the learned single judge?
Follow page 18 answers.
Please have a look at page 32. Paragraph 7, this is the case made out in the writ petition. Your petitioners with a heavy heart states that on 9th of September, when they were produced before the learned judge, they both in open court repeatedly complained that they were subjected to physical abuse by the police authorities, specifically in the hands of the respondent number 6 after their arrest, thereby grossly flouting the guidelines in DK Basu. Your petitioner number 2 even tried to show injury marks upon her hands and legs in the courtroom. Your petitioners have repeatedly complained of such abuse before the investigating officer of the instant case, being the respondent number 5 hearing, but of no avail. Even your petitioners, by way of severe intimidation, were not allowed to open their mouth before the medical officers during their medical examination about such heinous assaults on their person while in police custody. Even when your petitioners were again produced before the learned judge on 12 September 2024, they tried to raise their voice in the courtroom for the same. Your petitioners feel terrible when various cases of custody torture came in the fore, etc. But this is the case only made out in the writ petition. The other paragraphs, but according to me, are not very relevant unless my learned friends want me to place it. Now, these petitioners, they were produced before the learned judge. From time to time, those documents are also on record. Kindly take the first document, which is at page 80. Nowhere, when their advocates had represented them in the courtroom, there were any allegation in this regard. The first order is at page 80. Kindly have a look to that. Now, this was on a Sunday. Though this was before the learned ACJM, though this court is not having the jurisdiction to entertain the present case involving the alleged crime under the POCSO, but today being a holiday and had been produced before this court and in exercise of jurisdiction under 187, this court is empowered to remand the accused in judicial custody or in police custody for the initial period of 15 days or I think 5 days. Kindly skip over a few lines. Kindly take the next page. Second paragraph, the bail prayer accordingly stands rejected. The accused be remanded to something, I think, judicial custody. The controller of so-and-so correctional home to produce the accused before the learned special court POCSO at Diamond Harbour on 9/9/2024. So, JC on 8th of September 2024. Now, the 9th, when they were produced, please have a look at page number 88. But these were all placed before the learned single judge, but unfortunately, there is no reflection of this. This is on 9th of September. Please take the third paragraph. The bail petition is filed on behalf of accused number 1 along with Vokalatnama. Let the same be kept on record. Then, Milord, this is a case under section so and so, POCSO and IT Act, and the allegations against the accused is serious in nature. Considering the pair of the IO, the nature of the case, I am of the opinion that for verifying the leading statement of the accused to arrest the other involved accused and to prevent greater conspiracy, 3 days police remand is sufficient, and police remand of the accused is hereby allowed for 3 days. IO is directed not to assault the accused physically during the period, etc. Milord, DK Basu, etc. Milord is stated. Then kindly take, Milord, page number 89. After 3 days, Milord, on 12th, Milord, they are being produced. Kindly take, Milord, the fourth line from the top. The investigating officer, we're at page 89. Fourth line, the investigating officer has also filed medical reports of the accused persons. Now, kindly, Milord, skip over a few paragraphs. Kindly take, Milord, the fifth paragraph. Learned advocate appeared for the accused persons. But the fifth paragraph, learned advocate appeared for the accused person, submitted that most of the sections are bailable in nature and at this stage further PC is not required. Learned advocate further submitted that the principal accused has already been arrested in Moidan PS case and the above named accused persons have only clapped at the time of procession led by the principal accused so and so. So praise for rejection. But finally, Milord, if your lordships may kindly come to Milord, page number 90, second last line. Milord, they are remanded to judicial custody. Second last line. Milord, after perusing, Milord, the medical reports, Milord, these were the directions. But kindly take, Milord, an order dated 13th of September 2024. Mr. Dinda, kindly point out the page number of 13th September. Milord, that your lordships will find, Milord, from the supplementary affidavit. Kindly take note, 13th of September order. Please give the page number, Mr. Dinda.
Lordship, sir, page 4. Page 4 of the supplementary affidavit.
Now, this is an order on 13th of September. Kindly take note, the second line, the accused persons have also filed an application for bail. Let the same be kept on record. The investigating officer has filed a petition paying for interrogation of the accused persons in the correctional home for proper investigation of the case. Then, after 3 paragraphs, this has been the IO is directed to interrogate the accused persons at the correctional home in presence of so and so. The superintendent of the correctional home is directed to allow the investigating officer to interrogate the above named accused person. Now, this is on the 13th. Then, Milord, 14th, then 19th. Mr. Dinda, again, please give the page number.
Page 5, your lordship, the next page.
Well, this is on 19th of September. Well, please take note of the 5th paragraph. In the circumstances, I am not inclined to allow the instant petition filed by the investigating officer for production of the accused and hearing of the PC prayer before so and so. Accordingly, let the bail application along with the petition for 10 days PC remand of the accused be kept with the record for consideration on so and so. Learned advocate appeared on behalf of the accused, submitted that medical treatment of the accused person is necessary. As such, a direction may be given to so and so for providing necessary medical treatment. But there is no allegation of, Milord, any kind of torture. They only ask for medical treatment. Now, kindly take, Milord, the next page, which is, if your lordships may kindly come back to the main stay application once more. I'm so sorry. That is 24th of September. That is at page 91. But in chronology, Milord, I'm placing these orders. Page 91. Well, this is on 24th of September. But at page 91, please take the last paragraph. But every time, the accused are being represented through advocates. The learned advocate appeared on behalf of the accused person, submitted that the accused person, namely so-and-so, was arrested on rally and subsequently enlarged on bail by so-and-so. But again, she was arrested by the police in connection with Falta PS case, where we are concerned about Falta PS case. And she had been detained in judicial custody since 9/9/24. Learned advocate further submitted that on earlier occasion, this court was pleased to grant 3 days police custody. And after returning of the accused person for police custody, further police custody prayer of the investigating officer was rejected by this court, and subsequently the jail interrogation prayer was allowed by this court. And as per the order of this court, the accused persons were interrogated by the investigating officer in so and so. When an advocate further submitted that both the accused persons have been detaining in the judicial custody since 99, and it is only the allegations against them that they had instigated the principal accused for committing the alleged offence. Learned advocate further submitted that the accused person, namely Rama Das, is seriously sick. Kindly note this, Milord. This is very important. Seriously sick and is under treatment at the correctional home. Learned advocate pray for rejection of the application, etc. But the next order is dated 26th of September. Once again, Milord, your Lordship has to go to Milord the supplementary affidavit. Kindly, Milord, excuse me, Milord.
Page 6 of the supplement.
Page 6 of the supplementary affidavit, 26th of September. Third paragraph. Third paragraph, the accused persons, namely so and so, have filed bail application and a petition for call of a medical report from so and so regarding the treatment of the accused Ramadas. Let the petition be kept on record for consideration. But in that page, the third last paragraph at the bottom, send a copy of the order to the superintendent of the correctional home for providing necessary medical treatment to the accused, namely Ramadas, and submitting a report regarding the medical treatment on or before 5/10/2024. And finally, Milord, they have been enlarged on bail on 5th of September, 5th of October, I'm sorry, Milord, at page 94. Milord, last document, Milord, at page 94 of the stay application. But I'm so sorry, Milord, I have to, Milord, hop around here and there because, Milord, these were not part of the petition. But here is, Milord, the order granting bail, which is on 5th of October 2024. But please take note of the second last paragraph. I'm sorry, third paragraph from the top. Our learned advocate appeared on behalf of the accused person who submitted that the above named accused person, namely Ramadas and Rebecca, has been detained in the judicial custody for more than 25 days, and the accused, namely so and so, has been detained in the judicial custody for more than a week, and all the accused persons are women. And investigation also progressed enough. As such, further detention of the accused is not required for the purpose of investigation. Learned advocate further submitted that search and seizure has already been completed and custodial interrogation of the accused is not required. The learned advocate paid for bail of the accused persons on any terms and conditions. Then, Milord, kindly take, Milord, after two paragraphs, I have gone through the entire materials as well as the instant application for bail filed on behalf of the accused and the case diary, and find that the above named accused persons, namely so and so, has been detained in custody for more than 25 days and search and seizure has already been completed. I also find from the materials on record that the above accused persons were in police custody and during the said period, articles were seized, etc. Then finally, Milord, bail is granted. So many orders are on record. Accused were represented by advocates, no allegation. Now, I'll show, Milord, the medical reports also from day one. Now, the first is, but if your Lordship may kindly take page 77.
What is your point of grievance?
Well, my grievance is, Milord, the learned single judge, Milord, in spite of being placed, Milord, all these documents, but with respect, Milord, nothing is considered. A CBI investigation is detected, number one. Number two, my learned friends will agree with me, I suppose, that, Milord, possibly none of the parties were addressing the court on a possible CBI investigation. I was not called upon to address the court why an investigation shall be granted or shall not be granted. Now, Milord, kindly, Milord, in the backdrop of these documents, please take the order under appeal, Milord. How, Milord, the entire things, Milord, has been misconstrued. Please take, Milord, the order under appeal.
But the other petitioner is not present, sir. How can I
But,
pass?
Milord, please consider, Milord, I have served notice. And, Milord, please consider only one paragraph. But kindly consider one paragraph, Milord. I have a point. But I have a point. I'm sorry.
1 minute.
I'm sorry.
Sir, you are aware regard you have been served or no? You have been served in this matter.
Yes.
That is why, since you were there, I'm asking you, have you registered RC till now? Till now, it has not been registered. Since all the parties are not appearing, I'm keeping it on 4th of November before the regular division bench. Till then, I'm passing a direction that until and unless the regular bench passes an order on this appeal, since everybody is not appearing, this is vacation going on. The persons against whom allegations are made, they are not going to abscond also because they are regular government servants. So you take steps, whatever, pursuant to the regular court reopening. Till 5th of November, we are directing you not to give effect to the order. On 4th, the matter will appear before the regular bench. All right.
Very well. Very well.
And in the meantime, please effect service.
Yes, madam. Yes, madam.
Acha, affidavit of রেগুলার মিটিং ছুটে যায় কতক্ষণ হয় আমাদের ইনফর্ম করে এখন হবে আর যেগুলো আছে পালিয়ে যাবে না তারপর করবো
But subject to only one request. The first day, your lordship knows gets slightly difficult. Your lordship would give it for after 2 days, 2 days or 3 days. Your lordship knows first day, after a long holiday, what happens. Lordship understands.
So,
Not 4th and 5th gives the audit till 6th or 7th. Just 3-4 days.
4th, the matter appear instead of 4th, I'm keeping I'm asking the CBI up to 6th.
After 6th. After 6th.
Up to 6th.
Up to 6th.
Up to 6th. Instead of 5th, you wait till 6th for taking steps in respect of the single bench order. I am directing the matter to appear on 4th. Only 1 day according to their request. All right.
4th as well. 4th.
Acha. Affidavit of service file be kept with the record. Learned advocate, acha, in spite of service, none appears on behalf of the affected
One and two.
Writ petitioners, madam.
in respect of the writ petitioners. The grievance, learned advocate general appearing on behalf of the appellant draws the attention of the court to the regular orders passed by the jurisdictional court since the arrest of the writ petitioners. There are allegations in the writ petition for custodial torture being inflicted, which is controverted by the learned advocate general by drawing the attention of the court to the regular production orders of the writ petitioners before the jurisdictional court from 8th of September 2024 till they were granted bail on 5th of October 2024. Full stop. Learned advocate general submits that at least on 4/5 occasions, the writ petitioners were produced before the court, and on none of the occasions, and on all the occasions, they were represented by a learned advocate. However, there were no allegations that there were custodial violence being inflicted upon the petitioners. Full stop. It is also submission of the learned advocate general that it was nobody's prayer before the learned single bench in respect of any investigation to be transferred or entrusted to the CBI. In spite of the same, the learned single judge proceeded to direct the CBI to investigate the issue relating to custodial violence. Prima facie, I find that the police officers who were involved in the process of investigation are subject matter of issues
I will tell him also, but you tell him.
relating to custodial violence, if any, being committed. Although the same is denied by the state by drawing the attention to different order sheets of by the state by drawing the attention of the court to the different orders passed by the learned aid ACJM as well as the learned special court. Full stop. As the petitioners are not present before this court, it is very difficult to pass any orders deciding the issue either in favor or against any of the parties. Acha. DSP CBI Mr. Ashutosh Kumar is present in court who submits that he has received a copy today in the morning and he has instructions that till today no case has been registered by the CBI. As the persons who are subject matter of the issues belong to the police department and at the same time the merits of the matter cannot be entered into in absence of the petitioner. Further, there is no scope of the said police officers or other officers fleeing from the process of law. I direct the CBI to stall the registration of the FIR pursuant to the order dated 8th October 2024 till 6th of November 2024. List the
এখানে প্রফর্মা রেসপন্ডেন্ট প্রফর্মা লেখা আছে
appeal before the regular bench on 4th of November 2024. In the meantime, fresh service be effected upon the petitioners oblique respondents. Full stop. As directed above, we list the appeal on 4th of
প্রফর্মা 1 and 2 are appearing.
Mr. Banerjee enters appearance on behalf of the proforma respondent number.
Proforma 1 and 2. Proforma respondent 1 and 2.
Proforma respondent number 1 and 2. His power may be kept with the record.
Your Lordship, one indulgence subject to leave of the learned AG. The supplementary affidavit also taken on record.
আর একটা উপর প্রথমেই দিয়ে দেবেন affidavit of service প্রথমে দেবেন তারপরে দেবেন supplementary affidavit filed on behalf of the appellants be also kept on.
I'm grateful.